disqualifications, but what is important here is that some lawyers, there's a school of thought that because technically one can say she has met the specific 4 requirements to be a member of the House of Reps, she can be appointed a minister. But that is when you look at the matter at the surface.
Right.
Yes, it is much deeper than that. Now, the NYSC Act, I wish to emphasize, it's not just one of those acts of the National Assembly. The National Youth Service Corps Act, the National Security Agencies Act, the Land Use Act, I think one other legislation. They are part of what is called existing law. These are laws that have been incorporated into the Constitution, that have been made part of the Constitution. Even the National Assembly cannot amend the NYSC Act without going through the same constitutional amendment process in Section 9 of the Constitution, 8 and 9, as it relates to amendment of the Constitution. So the NYSC Act is an act that has a constitutional flavor. What that implies is that when you violate the NYSC Act,
you are violating the Constitution.
That is the implication. Now, what does the Act say on this matter? Section 2 of the NYSC Act says that if at the time of your graduation, which is the provision that is applicable to her, you are less than 30. Note, at the time of graduation.
Yeah.
Meaning that if you graduate at the age of 28 and you don't serve, even at the age of 70, you are to be called up to serve Nigeria. That is the implication. She, having graduated less than 30, she was statutorily required to submit herself and enroll and be called up to serve. She said she had done that. The record shows she had made that attempt. She was deployed to Enugu and redeployed to Adamawa, I think so. Now, there was a controversy on what really happened during her time of service at the time. She says initially that she had obtained a certificate, but during a fire incident in her residence, she had lost it. Subsequently, the NYSC found that there was actually a certificate with her name, but that she had absconded from service. So they refused to issue a fresh certificate. She wrote to the then Minister of Youth, Sunday Dare, to appeal against the decision of the NYSC board. That did not yield results. I guess after repeated efforts to resolve the issue and the statute of her service, she decided to go back to serve. Now, having gone back to serve, I would have thought she would complete that before undertaking any exercise. Because Section 2 says, of the NYSC Act says, you are to serve for a continuous period of 12 months. 12 calendar months, which is effectively 1 year. Continuous. Now, when you look at paragraph 4 of the NYSC bylaws, 2011 as revised, you are not permitted, it is even an offense as a corps member for you to engage in partisan politics or any sort of political engagement. Now, to show how more serious the matter is, by virtue of paragraph 2 of the fifth schedule to the Constitution that contains the code of conduct for public officers, a public officer is not allowed to earn double emoluments. Because as a corps member, you are entitled to monthly stipends called alawi. Yes, you're entitled to alawi. She's entitled to alawi. She cannot collect alawi and collect salary as a minister, collect, at the same time, allowances as minister. That itself is a violation of the code of conduct, which is also a criminal offense. Yes, the matter is that serious. But then, the matter is that serious.
But then everything about NYSC is all about service, National Youth Service Corps. So what she is doing currently, can it be seen as service? Because what NYSC
service
said,
to her fatherland.
Yes, what NYSC said, you can't engage, you can't also engage in personal businesses as against you being an NYSC member, serving in your PPA and all of that. But what she's doing is also serving her fatherland. Can it be seen in that regard? Because it's all about service at the end of the day.
Well, the intention of the law is that nobody should die while serving his father's land. So you don't have to serve Nigeria.
But it's not your die. It's not your die. It's my die.
The important point is this. The important point is this. I explained the nature of the scheme and said that the law is that it should be continuous.
Yes.
But guess what? I had even taken this position that our role as a serving corps member and a minister is illegal. But last night, I came across a Supreme Court decision on the matter. That in 2019, someone was actually declared winner of an election in the Yola North, Yola South Federal Constituency of Adamawa State under the platform of the APC, right? The matter went to court. Mr. Modibo, the case of Modibo and Usman. You know what the Speaker said? And this was election into the House of Reps, which is the constitutional basis for being eligible to run as a minister. The Supreme Court held that because this individual, the appellant in the case, Mr. Modibo, at the time was a serving corps member, he was not eligible to contest election into the House of Representatives on the platform of the APC. This is a Supreme Court decision.
But that is a contest. It is different from being appointed.
No, the Supreme, in fact, I can read the text of it. You know, I had to come with it because, I mean, it entirely clarifies the matter. Can I read it?
Go ahead.
So that Nigerians will know. The Supreme Court said, the learned trial judge found upon overwhelming evidence before him that at the time the appellant cross-respondent was nominated to contest as the candidate of the APC, second respondent, to contest the general election in the Yobe North, Yobe South, Giri Federal Constituency. He was a serving NYSC member. On this fact, the trial court held consequently that the appellant, having contravened the 9th paragraph of Section 4 of the NYSC Act bylaws, revised 2011, he was prohibited from participating in partisan politics, and that for that period of compulsory 1-year service, the appellant was disqualified from contesting the 2019 general elections. Right? The court went further to say that, you know, let me just go to the summary part of it, and then held that that to me appears, yes, of course there was an argument on the matter. The lower court, however, was of the contrary view, agreeing with the appellant's counsel that the appellant's conduct, which was merely an act of disobedience to the NYSC rules, for which he was liable to 3 months extension without pay, would not operate to disqualify him from contesting the 2019 general elections. It appears that the lower court has suggested quite obliquely that the appellant, an undoubted NYSC member, and indeed any NYSC member, could combine the full-time activities as a member of the House of Reps. That to me appears absurd. The lower court failed to be guided by the overall public policy in the National Youth Service Corps Act. Neither the lower court nor the appellant satisfactorily addressed the point raised by the trial court and the first respondent, that public policy under the NYSC scheme and bylaw made pursuant to the NYSC Act forbids a corps member from going into politics or holding a partisan political appointment.
Right.
So the court went further and then ruled that this was even a crime. The penalty for causing or abasing another corps member to contravene the provisions of the Act is 5,000 naira fine or imprisonment for a term of 3 years or both. So clearly the law made it clear, the Supreme Court made, this is the decision of a JMB Eko JS, that you cannot be a serving corps member and then occupy a political appointment.
Or an appointment.
And this applies to any corps member. So whether it is election into the House of Reps, ministerial positions, or board appointment, during the currency, during the tenure of your continuous 1-year service, you cannot be involved in partisan politics. You cannot hold a political appointment. That settles the matter.